Coming to the very first topic of today's discussion, imagine a person lying in a hospital bed from the last 13 years, unable to move, unable to eat on his own, unable to recognize his family members. And imagine the parents every day coming to the hospital, they are standing beside him, thinking when or if ever he'll be recovering from this position or he'll be recognizing them or not from the last 13 years. This is not an imaginary person, this is the condition of Harish Rana, whom Supreme Court in the recent judgment has allowed to undergo passive euthanasia. So the first article talks about how Supreme Court in the recent judgment of Harish Rana case 2026, they allowed passive euthanasia for the first time for a man in permanent vegetative state from the last 13 years. Now, in this topic, we'll see what is euthanasia, what are the different forms of euthanasia, how it has evolved over time, what are the different judgments in which Supreme Court has laid the guidelines for this, what is Ministry of Health doing regarding this passive euthanasia, and what are some of the dilemmas around euthanasia in India. Now, this topic is important for you guys, not only for the GS paper 2 polity, where we talk about fundamental rights under Article 21. Article 21 talks about right to life. Also, along with it, Supreme Court said that this Article 21 now also contains right to die with dignity. That's why they have recognized passive euthanasia as part of a fundamental right for a specialized case in a situations where person is in permanent vegetative state. Fine. After that, this is also topic is part of GS paper 4 of ethics, where we will see the ethical dilemmas, medical ethics, and right to die with dignity with the lens of ethics. That how allowing a person to die or protecting his life, how it creates a dilemma for not only the family members but also for the doctors in the hospital. Fine, so let's start with euthanasia. What does euthanasia mean? It is often referred to as mercy killing. Mercy killing, basically you are relieving somebody of the pain what he is going through. A person, if he is in the permanent vegetative stage or he is brain dead, then you allow that person to die uh, to relieve from that suffering. For example, the Aruna Shanbag case, that lady was in this brain dead, or you can say permanent vegetative state, from the last 4 decades before she finally died of pneumonia in 2015. So this sometimes becomes a issue, that whether you keep that person alive, you keep on regularly providing them the medical support, medical health care, or you let them die with dignity. So it is defined as hastening of death of a patient to prevent further suffering. Hastening of death means you are allowing him to die naturally before time by withdrawing the life support on which the person is alive till now. Now this word comes from Greek word eu means good, and thanatos means death. Euthanasia, that means good death, which means good death or death with dignity. Fine, so this is the meaning of the term euthanasia. Now the constitutional basis says, as I've just told you, Article 21, which says that right to life and personal liberty, under which the Supreme Court has interpreted that this right to right of life and personal liberty also includes not just living but living with dignity. So if the person is in that stage in hospital where he is not living with dignity, let him at least die with dignity. We let him be relieved from the pain or the suffering he is going on every day, where he cannot even talk, he cannot even express his pain, he's just lying on the bed. Fine. Now talking about the types of euthanasia, first is voluntary euthanasia, where the patient's informed consent or in the form of living will is recognized, or a person can write his will that once I go into some kind of accident or in this stage, in the permanent vegetative stage, let me die. Let me die through passive euthanasia. Just like a person writes his will that his property will be distributed in such and such manner after his death, similarly a person can write a living will also, what can be done with his body once he is not in his senses to take any decision. Second is non-voluntary, where the decision by a surrogate or a family or court for an incapacitated person is taken. Now the person has not made any will, he has gone into incapacitated state. Now somebody else on his behalf can take decision. They can be either family member or court or doctors maybe. And last is involuntary, where the patient is capable of giving consent but not asked. This is largely illegal. It is also considered a part of murder. Fine. So basically among this we have two types of euthanasia, active and passive euthanasia, where we have to focus. Active euthanasia is positive or aggressive euthanasia, and passive euthanasia is negative or non-aggressive euthanasia. What do you mean by aggressive, non-aggressive? Basically in active euthanasia, the intentional death by direct intervention is performed to end the meaningless existence by lethal doses of drug or injection. Basically in active euthanasia, the person is given a drug to end his life. A dose of drug, or you can say a medicine or an injection, is given inside the body of the person, through which he dies smoothly without any pain. But you are giving something from outside in his body where he dies. But in passive euthanasia, intentional death is caused not providing essential care or food or water, basically by discontinuing the medical treatment which we are giving to that person. You just stop the treatment and let the person die in a natural death. Or withdrawing or removing artificial life support, basically the ventilator, the feeding tube, you remove all them, and if the person doesn't get the ventilator support or the feeding tube support, he will automatically die after some time. And this is also done in a smooth process where the patient does not go through immense pain during dying. So in this active euthanasia, there is quick death and all forms are illegal in India. Now this is important for you guys. This can be asked in prelims also, and it is not allowed in India. But passive euthanasia, it is slower, uncomfortable, and all forms are legal in India now. It is allowed in India by the Supreme Court. Fine. So we'll see how it evolved over time. What were the different cases in which Supreme Court talked about passive euthanasia? First in 1994 in the P. Ratinam case versus Union of India, where the Supreme Court held that right to die is part of Article 21 of right to life. Supreme Court recognized this thing in 1994. But 2 years after that, in Gyankor versus State of Punjab case, the Supreme Court reversed its previous jurisdiction. Basically, they said that they held Article 21 is for protection of life and not for its extinction. That means right to life is for living. You cannot take away life. It is not for extinction, or you can say um, removing life of somebody. Now, in the 1996, just 2 years after the previous judgment in Gyankor versus State of Punjab case, the Supreme Court reversed its previous judgment, where they said that Article 21 is for protection of life, not to take away of somebody's life. Fine. And finally, in 2011, it was a landmark judgment in Aruna Shanbag versus Union of India case, where for the first time the court recognized passive euthanasia in rare cases under judicial monitoring. That under the monitoring of court and judicial magistrate and doctors, somebody with on a special case basis can be allowed to undergo passive euthanasia. But in this case, Aruna Shanbag was not allowed to undergo passive euthanasia. Why? Because the nurse who was taking care of Aruna Shanbag from the last 4 decades, she was her friend. She said that I'll take care of Aruna Shanbag in any state, and it is my responsibility to take care of her. I don't want her to die. But later on, after 4 years, she died of pneumonia disease. But in 2018, again, it was a major judgment in Common Cause versus Union of India case, where the Supreme Court declared that right to die with dignity is a fundamental right under Article 21, and it legalized advanced medical directive, which is called living will. We already discussed living will. Living will is a legal document specifying an individual's preference for medical treatment if they become incapacitated. That means if they are not capable of now taking decision on their own, they have already taken decision and put it in living will when they were in their senses. So after this 2018 case where the Supreme Court recognized right to die with dignity, finally after 7 years in 2026 Harish Rana case, for the first time practical implementation of this thing has happened, where Supreme Court recognized removal of life support, specifically the feeding tube. The feeding tube which was feeding food to Harish Rana will be removed for a 32-year-old after 13 years of vegetative state. He was eating food from the feeding tube from the last 13 years. He was not able to move, not able to eat anything. Harish Rana basically fell from a floor building and sustained some head injuries, after which he came into the vegetative state. Now, for the first thing here is that for the first time, Supreme Court explicitly ruled that feeding tube is a medical treatment and not just basic care. Feeding tube is a medical treatment. That means with the help of feeding tube or machines. If you are providing food to somebody, that is also part of medical care. It is not basic care. So in this case, what Supreme Court said, basically you remove the feeding tube. After some time, slowly Harish Rana will undergo passive euthanasia on his own. So we'll not be injecting any drug into him to let him die, but we'll just remove the feeding tube or medical support. Clear? So now we'll see what are the procedures established which should be followed in case of any passive euthanasia. First, there should be a living will. A living will, as we have discussed, it is advance directive stating whether a person wants refusal of life support treatment in terminal illness. Terminal illness are those where the person does not have any chance to recover in future, or conditions under which the treatment should be withdrawn. The person in his will, they can write that under such and such conditions where the chances of recovery are very low or the time taken will be infinite, they can withdraw their life support. So they can put their wishes in the living will. Second, then after this, if the living will is not there, 2 hospital medical boards will be created of 3 members each. There will be a primary medical board and a secondary medical board. The primary medical board will be created at the treating hospital. In whichever hospital the patient is there, on that particular hospital, a primary treating board will be created. After that, to keep an on-site, or you can say oversight over that primary board, a secondary board will be created with external experts and doctors included in it. Again, it will be a 3-member committee. Now, earlier Chief District Medical Officer was part of the secondary committee, but in the 2023 guidelines by Ministry of Health and Family Welfare, this section has been removed. Now, a nominee of Chief District Medical Officer can be part of this committee. Basically, it reduces the cumbersome procedure required in creating this committee. Now, after receiving the consent of the patient's family or the legal guardian, they can move ahead. And after the final approval by the hospital authorities, the patient can be admitted to palliative care facility. Now, in this case, Harish Rana will be admitted in AIMS palliative care facility. Palliative care facility are basically special type of facilities which are designed to reduce pain of a patient, which are designed to take extra care of a patient, at least when they are dying, where life support can be withdrawn humanly, ensuring dignity and comfort even in the death. Fine. So Ministry of Housing and Family Welfare created our draft guidelines. They brought out draft guidelines regarding euthanasia. Basically, they said that supportive care can be withdrawn if a person is brain dead. Brain dead means that you are not able to function on your own. You are not able to move your body. You are not able to think and sense something. You are not able to recognize your family. All those things. An informed refusal is documented. Basically, if the person has written in the living will that his medical support should be withdrawn. Or the guidelines also talked about medical boards which will decide when the treatment is futile for terminal patients. That means after which point the treatments are insignificant for the patient. There are no chances of recovering. They also talked about how hospitals must form clinical ethical committees for audit oversight and conflict resolution in case of any euthanasia issue coming, because see, these are sensitive issues. At these times, the patients, the entire family of the patient, they are in a kind of trauma. So an ethical oversight committee, a regulation committee has to be made by hospitals. Now these guidelines were brought out by Ministry of, in 2023 by Ministry of Health. Now, what are the different arguments in favor and against euthanasia which can be used to write your mains answer? The arguments in favor are basically your autonomy over the body of individual. That this is my body, it is my right to take decision over my body. Respect individual sovereignty over their own body. Then dignity in death, by relieving patient from the unbearable suffering. See, the patient is lying still, he cannot speak, he cannot express himself. Who knows what suffering he is going through? So what if we think that the patient is completely fine, he's not going through any suffering, but internally he is suffering a lot? So it is our duty, or you can say duty of doctors, to relieve him from that suffering. Then medical futility, withholding treatment that offers no real chance of patient recovery. When the chances are almost nil or negligible, you can withdraw treatment. It has to be withdrawn. Or organ donation, it can potentially save many lives. Imagine a person is lying almost dead on a hospital bed for 4 decades. Now, if the person wants or have a living will that I want to donate my organs once I become in this incapacitated stage, then it can save a lot of people's life. In India, we have huge shortage of organ donation. So this is also required in our country. Then financial relief. The families sometimes are not financially well off to take care of the medical bills coming for this treatment. So the families, by avoiding prolonged and costly treatment, they can also be relieved. That money can also be used in some other um, old age person's care or a child's studies. And last is judicial recognition for the right to die with dignity, Article 21. Now the judiciary and the Constitution Article 21 has also recognized right to die with dignity as a fundamental right. So these all are the arguments in favor of euthanasia. Now we'll see some of the arguments against euthanasia. Some arguments against euthanasia, which says first is religious opposition. Basically, in religions like your Christianity and Islam, euthanasia is often opposed because life is gift of God. Life is gift of God, and only the God has the right to take away life. Only God has the authority to take it away. There is a potential of abuse in some cases also. See, India is famous for abusing whatever laws we create. People do find some kind of loopholes and they are then misused. So here also, non-voluntary euthanasia, where consent is not clear and may lead to coerced consent. That means, what if a person has created living will but his consent, or you can say the will, has been forced upon him? So there can be misuse. Then we have slippery slope. That means the fear that it may lead to involuntary killing of elderly or disabled for financial gains. Let's say somebody wants to take property, somebody wants to take insurance money, and all those things. Anything can be there. So again, it may lead to immoral practices of involuntary killing. And last is undermines medical ethics. Doctors take Hippocratic oath to save each and every life. Now, this Hippocratic oath to preserve life is violated in case of euthanasia. So, doctors are in a dilemma in such cases. Then, what should be the way forward? What should we do regarding euthanasia? First is the legislative action. The Supreme Court in 2026 explicitly they urged the center government to enact a comprehensive law on end of life care to move beyond the judicial guidelines. Right now, euthanasia, the procedure regarding euthanasia, their entire steps, they are just working on Supreme Court guidelines. Now, Supreme Court says that center has the responsibility to make law regarding this. It should not just run on the Supreme Court guidelines. So you have to make a comprehensive law regarding this. Then palliative care, need to integrate palliative care or pain relief or comfort care into the National Health Mission. So death isn't the only escape from pain. So palliative care should be given priority so that the patients in this case they are relieved from pain. They should not only think that death is my only option to relieve this pain. The palliative care should be able to remove their pain. Then your digital integration, linking the living will to Aadhaar or Ayushman Bharat digital health account for easily accessing by the doctors. Now it is available just like your documents which are available on DigiLocker. Similarly, it can be linked with Aadhaar or the Ayushman health records, digital health records where doctor can easily access based upon providing some details of the patients. Then public has to be made aware regarding this, normalizing conversations around death to reduce the stigma and legal fear among the doctors. A lack of awareness is a major issue in our country which has to be resolved. Then clear hospital protocols with uniform national guidelines for the hospital has to be created, which will be part of any law which if it is created by the central government. Then we have to safeguard against the misuse. Strict medical and legal oversight has to be given, and anybody found misusing this provision has to be dealt with very severe punishment so that a precedent can be set regarding this. And finally, ethical training of doctors, training in end of life decision making, because right now nobody gives this kind of education to doctors. Doctors do go in a lot of trauma when they face severe dilemmas regarding saving patient lives. Now we'll see what are some of the other countries doing. Now this euthanasia is legal in countries like Netherlands, Belgium, Luxembourg and Spain. In all these countries, passive euthanasia is allowed. But however, in some countries like UK, in UK, it is considered illegal. In United Kingdoms, and it is equivalent to manslaughter. So they consider passive or active euthanasia equivalent to manslaughter. It is highly illegal. In some states of USA, it is again allowed, but not in all the states. Similarly, New Zealand or your Switzerland, they bans euthanasia but allows assisted dying in the presence of doctors. That means some form of euthanasia is allowed there, but not entirely. So in this lines, we can also create some of the legislation, palliative care, public awareness, digital linking of living will, and training of doctors. All this has to be done in India also. Now, based on all the discussion which we have done till now your job is to write an answer on this topic. The question says, recognition of the right to die with dignity marks an important evolution in India's understanding of the right to life. Discuss in the context of euthanasia and recent Supreme Court judgments. Now, this will be a 2-page answer in 150 words. Make sure you guys are writing and practicing this.